Peace, y'all. I'm right back at it. It's Taj with the Black's Law definitions as promised. Like I said, we going somewhere with this. Is definitely a definitive. Bear with me. Starting a YouTube channel shortly. If you don't mind when I do post, please take the time to subscribe, like, comment, share, all that good stuff. Like I said, I learned from the best. Peace to you, Kev. All right. So we're going to pick up at mind. So in Black's Law Dictionary, 5th edition, mind and memory. It's a phrase applied to testators denoting the possession of mental capacity to make a will. In other words, one ought to be capable of making his will with an understanding of the nature of the business in which he is engaged, a recollection of the property he means to dispose of the person who are the objects of his bounty, and the manner in which it is to be distributed between them. See also capacity. All right, then we'll go down to mind, the state of mind. Its evidence is admissible to show a person's state of mind when this issue is material and relevant to the case. E.g., statements indicating despair may be admissible on issue of suicide. See also mental state. All right, so from there, let's swing it over. And what we're going to deal with now is insanity and insane delusion, building on yesterday's definition of delusion. So insane delusion is a conception of a disordered mind which imagines facts to exist of which there is no evidence, and belief in which is adhered to against all evidence and argument to contrary, and which cannot be accounted for on any reasonable hypothesis. All right, so now we're going to drop down into insanity. And insanity is the term is a social and legal term rather than a medical one, and it indicates a condition which renders the affected person unfit to enjoy the liberty of action because of the unreliability of his behavior and co-committing danger to himself and others. The term is more or less synonymous with mental illness or psychosis. In law, the term is used to denote that degree of mental illness which negates the individual's legal responsibilities or capacity. All right, insanity as a defense to crime. There are various tests used by the courts to determine criminal responsibility or lack thereof of a defendant who asserts the defense that he or she was insane at the time of a crime. The test, as provided in section 4.01 of the Model Penal Code, is as follows. A person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease or defect, he lacks substantial capacity either to appreciate the criminality, wrongfulness, of his conduct, or to conform his conduct to the requirements of law. This test, as defined by the American Law Institute, has been adopted, sometimes with slight modifications, by a number of states and also in the various federal courts of appeal. If a defendant intends to rely upon the defense of insanity at the time of the alleged crime, he is required to notify the attorney for the government of such intention. All right. Also, see automatism, diminished responsibility doctrine, Durham rule, irresistible impulse, M'Naughton rule, and right and wrong test. For various other tests used by courts to determine criminal responsibility of defendants who assert insanity defense. See also competency, incompetency, insane delusion, lucid interval, lunacy, melancholia, sanity hearing, substantial capacity, uncontrollable impulse. All right. Insanity as affecting capacity. Capacity to make a will includes an intelligent understanding of a testator's property, its extent and items, and of the nature of the act he is about to perform, together with a clear understanding and purpose as to the manner of its distributions and the persons who are to receive it. Lacking these, the testator is not mentally competent. See also capacity. All right. That being said, we're going to dip over into competent. We're going to start with competency. In the law of evidence, the presence of those characteristics or the absence of those disabilities which render a witness legally fit and qualified to give testimony in a court of justice applied in the same sense to documents or other written evidence. Evidence which is admissible as being able to assist the trier of fact, i.e. the jury, in determining questions of fact, though it may not be believed. Competency differs from credibility. The former is a question which arises before considering the evidence given by the witness. The latter concerns the degree of credit to be given to his testimony. The former denotes the personal qualification of the witness, and the latter his veracity. A witness may be competent and yet give incredible testimony. He may be incompetent and yet his evidence, if received, be perfectly credible. Competency is for the court, credibility is for the jury. Yet in some cases, the term credible is used as an equivalent for competent. In law of contracts of legal age without mental disabilities or incapacity. See also ability, authority, capacity, and competent evidence, duly qualified, incompetency, power, and qualified. All right, so I'm going to just skip down and we'll just go to, it's a lot of other ones you can go to with competent and competency, but we're just going to say just competent. That is duly qualified, answering all requirements, having sufficient ability or authority, possessing the requisite natural or legal qualification, able, adequate, suitable, sufficient, capable, legally fit. A testator may be said to be competent if he or she understands 1. The general nature and extent of his property, 2. His relationships to the people named in his will and to any people he disinherits, 3. What a will is, and 4. The transactions of simple business affairs. See also capacity, competency, incompetency. All right. Last but not least, we're going to go to capacity. Capacity is the legal qualification, example, legal age, competency, power, or fitness, ability to understand the nature and effects of one's acts, the ability of a particular individual or entity to use or to be brought into the courts of a forum. See also competency, disability, earning capacity, fiduciary capacity, incapacity, legal age, legal capacity to sue, mental capacity or competence, persons under disability, standing to sue doctrine, substantial capacity, testamentary capacity, criminal capacity, accountability for committing a crime, e.g., child under 7 years of age lacks criminal capacity. All right, and then capacity defense. It's a generic term to describe lack of fundamental ability to be accountable for actions, as one under duress lacks the capacity to contract, and hence when sued on such contract, he interposes defense of lack of capacity. Similarly, a child accused of crime committed when he was under the age of 7, his defense being the lack of criminal capacity. As a defense, it tends to negate some essential element of the action required for responsibility. See also competency proceedings, competency to stand trial, defense, insanity, intoxication.